and welcome to Overview of General Corporate Law Compliance, Corporate and Regulatory Compliance Boot Camp, Part 1. Pleased to be here today with Rob Seeland and Alyssa Habert. We'll introduce them in a second. And we hope you will get many takeaways from this. I want to thank our producer, Financial Poise, that provides practical and entertaining education for attorneys and other business leaders. And thank you to our co-producer, the National Law Review, which is a premier legal news website offering in-depth analysis on a wide range of legal and business topics. I want to make sure we cover the disclaimer and make sure that for Rob and Alyssa and myself, the material in this program is for informational purposes only. It should not be considered legal, financial, or other professional advice. If you need help with things, you should consult with an attorney and another appropriate professional to determine what may be best for the needs of your specific situation. And while the webinar products, producers, and speakers take reasonable steps to ensure that the information presented is accurate, we make no guarantee in this or any other regard. And so none of this is to be attributed to any of the speakers, our law firms, or corporate clients, future, past, or present. I want to introduce you to the faculty. My name is Dan Cotter. I'm a partner at Dickinson Wright PLLC in Chicago, where I handle a large variety of corporate and transactional matters and spent 16 of my 30 years so far in-house at large insurance companies in senior roles, including general counsel. Rob, if you want to introduce yourself, and then Alyssa will have you introduce yourselves.
Sure. Hi, I'm Rob Seeland. I'm founder and CEO of Lighthouse Legal Counsel, a small transactional boutique in Chicago. I spent about 10 years in-house leading transactional and corporate securities practices. And prior to that was working at two major law firms in Chicago. So my experience is primarily in compliance as well as corporate and securities matters.
Hello, my name is Alyssa Habert, and unlike my colleagues, I have not been in-house. I have all my practicing career been a Delaware corporate lawyer. And in that capacity, I work with other lawyers such as Dan and Rob, or retained by companies directly to advise on the Delaware aspects of transactions. It can range from public companies to private companies to investment funds with a lot of limited partner issues, LLCs, etc. Any type of transaction that touches Delaware, whether the documents are governed by Delaware law or we have Delaware entities involved, that's where I come in to help with those nuances. And I have been, since 2010, one of the appointed members of the Delaware Corporate Council, which is involved with meeting and analyzing and recommending to the legislature each year issues that we think need to be amended or supplemented or introduced into the Delaware business statutes to reflect what we're experiencing in our work and in the courts.
And you'll hear more from Alyssa later on some of the major developments in Delaware. And as we talk about Delaware in a few minutes, and she has, as Rob and Alyssa and I were preparing for this, just some major interesting developments that she'll cover in a few minutes. So about this webinar, and I'm not going to read the whole slide, but this is an overview of general corporate law compliance. And as you'll see, I think you get the slide deck eventually. One of the things that you'll learn as you get the slide deck and eventually watch it, if you're not watching it right now, is that Rob and I and Alyssa and I, in preparation for this webinar, we talked about the nuts and bolts are important. And for some of you, that may be important to understand kind of the basic framework and basic skeleton of corporate governance and all that. But we're also going to dive into some other topics that are, we think are of vast importance, like we talked about with Alyssa, talking about Delaware. Rob will talk about some of the tsunami and seascape that's changing every day in terms of corporate compliance and governance and how we navigate those. We'll talk about that stuff as well. And this is the first of the boot camp series. This is this session is the introduction. There's a number of other sessions in this corporate and regulatory compliance boot camp for those that are interested in diving into some of the very particular issues, including procurement and government contracting, which will be our next one in May, the Foreign Corrupt Practices Act. And again, we'll talk briefly about that today. There's been some developments that may impact some of that compliance seminar by the time it gets here in June, data privacy and some other things. So the episode 1, this is the overview of general corporate law compliance. We're going to speak in plain English. You know, hopefully most lawyers do. That's been my goal since I got into this profession. But I understand that some see us as talking like space aliens sometimes with Latin terms or other whereases and wherefores, a lot of commas and semicolons. So let's turn and start getting into the meat of this topic. We're going to talk about state corporate statutory compliance. And again, we're going to go through some of this kind of quick because some of this is pretty basic. And if you're doing this stuff, maybe if you're new to in-house or to a private practice, you're a young associate or a paralegal, some of the stuff is more important. But we'll talk about franchise tax and annual reporting, the regulation and operation and manner of action. We'll get into some Sarbanes-Oxley again. If you're at a public company or one that's registered, you know what that looks like. But one of the things I want to talk to and have Rob talk about a bit before we dive into some other stuff. There's an act that's been out there for some period of time for anybody that has a small business that's incorporated in the United States. It's known as the Corporate Transparency Act. I think this is probably like a version of Bleak House. I know my law firm's put out since July of 23, probably 20 now bulletins, many in the last few months as this goes up and down to the Supreme Court and stuff. So Rob, do you want to talk about the Corporate Transparency Act and where we're at and kind of a little bit of history and the clash between what's been done at the administration versus the fact that the act remains on the books?
Yeah, it's a quirk of U.S. law that most companies, when you do register, when you incorporate your business, you don't need to disclose who the shareholders are. Often the business is formed before the stock is issued and who the shareholders are. So there hasn't been a lot of transparency, unlike other foreign jurisdictions, as to who the ownership has been. And so that's put a lot of burden on money, tracking where money flows go. If the stated recipient of cash is a corporation, the question is who's really getting the money. The burden as a result has been really put on banks to track that. And that only goes so far. And so to kind of put some added teeth in this, back in 2021, they passed the Corporate Transparency Act. It was actually included in a defense reauthorization bill that said that all companies, with numerous exceptions, would have to disclose who the beneficial owners of the company were. From 2021 and through 2024, companies knew it was coming, but had no action to take. Coming in 2024, the rule became if you were incorporated in 2024, you had 90 days to report it. And if you had been incorporated prior to 2024, you had until the end of the year. So in this world, there was a lot of kind of white papers about it. It's coming, get ready, etc. And as it came, it was delayed, and then ultimately it was subject to litigation. And it's been fun for lawyers to see that it was actually kind of stayed the enforcement, and then the court that actually stayed the enforcement overturned that stay, and then it was actually enforceable again. And now with the new Trump administration, where we're at is that it doesn't apply to U.S. companies anymore. It still applies to foreign companies that are registered in the United States, which is a very small subset of companies. Most companies would just be would have a U.S. presence at that point and incorporate. And everyone else is in this situation where, and we'll find this with a lot of laws we're talking about with compliance, that they can follow this regulatory guidance, but this is still a law on the books that you're supposed to incorporate. I think most people will find that they're just not going to worry about it because the Department of Treasury issued some interim regulatory guidance that I think people can reasonably rely on. But it's kind of a symptom. It's kind of an example of the shifting compliance landscape that we'll be seeing. We really do need to monitor the laws. Things that we think are kind of sure can change on a dime at this point. And this is certainly one where people were planning compliance measures for the past 3 years, and it no longer should be in effect at this point. But it could come back any day, really.
Rob, with that in mind, do you suggest that people, if they've already prepared to comply, just go ahead and file?
I think there's some downside to that. I particularly if you're potentially going to be acquired, sometimes the acquirers are not actually subject to the law, and then it kind of creates a quandary for them of, well, what do we do with this? How do you unregister it? Do I now need to update this, and it forces me to report some kind of ultimate beneficial ownership? So I think, really for now, my recommendation would be probably not, but obviously consult with your own counsel because every company's situation might be unique.
Sure.
Yeah.
Thank
Yeah, I
you.
think it's good. Yeah, I think it's good advice, Rob. And the interesting thing with the Corporate Transparency Act is most federal laws and even state laws for like cyber compliance and stuff, if you're in certain industries, they usually have a minimum threshold. And if you're under that, you're exempt. This one was the flip. I mean, the main focus is companies 5 million in revenues or less, which again is not some of the questions and I think criticism of the Corporate Transparency Act was the companies that are doing that are mom and pop places and probably not what you're looking for in terms of, like you talked about, Rob, bad acting or potential, having, owners that are not supposed to be owning and things like that. So, and like Rob said, it's one of these things where I agree with you. I don't think you should file for a lot of reasons, including the data, even though it goes to FinCEN and is supposed to be confidential. Again, with Doge and everything, there's all this talk about whether data is being taken or accessed from people. And we saw the Panama Papers. I mean, there's no real good reason right now to comply. But on the other hand, like Rob said, this is just a memo or bulletin from FinCEN. And in the hierarchy of laws, when I used to teach accounting, we would talk about the hierarchy. There's the act, and then there's regulations, and then if it's SEC, there's the SEC General Counsel opinions, and you have to go through this kind of hierarchy of where a bulletin fits in. But
well, that's why I read, if after the fact they decide to enforce it and they look and see that by December 2024 you failed to comply, I don't want to be in that position.
I agree, and that's the tough part, right? Is and a lot of companies, I think, in this interim, not knowing where this was going, because there was a lot of challenges, even for the transition and for the new administration. The Supreme Court looked at it and said it was okay to keep enforcing, and that there were Fifth Circuit cases, but I think you're absolutely right, and that's a dilemma, like in all compliance, right? Is you probably advise your clients, I advise my clients, here's the situation. And like you said, here's what can go wrong, right? Congress changes or somebody revokes the bulletin and now says it's November of 24. You didn't follow the March 21st deadline or whatever deadline it was.
Right. But I would draw the distinction with new companies that are being formed. Maybe that's a comfort line.
Yeah.
We could suggest.
Yeah.
Well, Rob say don't bother there because it's so in flux. No one's, perhaps that's where you draw the line.
Well, that raises, and we'll get off of CTA, but that raises an interesting issue as well, Alyssa, because one of the things that as Rob said, if you were formed in 2024, you had 90 days. And again, many companies, a lot of companies did it and just filed, but a lot of companies were kind of waiting to see if this would be enacted or not. And all the bulletins and stuff, I think, are about companies formed before 2024.
Yeah.
So these companies, they're technically been out of compliance for, in some cases, a year, right? Because they formed in, say, March of 2024. They never filed. It's now March of 2025. So will they get the same grace, or will somebody come after them and be, you violated your obligations? So,
Yeah, and I would say in addition to, I think it was Rob that mentioned, how so many mom and pops get, brought into this. I'd also say on the other side, there's many public companies who have hundreds of subsidiaries, each that are, 100% owned, but they each serve a certain purpose within the larger organization, and these companies have to go and
yeah,
comply with these hundreds of subsidiaries and address and disclose what needs to be. First, they have to decide what has to be disclosed, and then go ahead and disclose it if necessary. And that's a chore.
it is, right? A lot of excess impact. So in any event, we wanted to raise the CTA because it's a big influx, and we'll be talking in a little bit about some other kind of where the landscape is uncertain, and Rob will guide us through some of that, of how, again, you nimbly navigate those things, especially as in-house counsel or as outside counsel advising your clients on how to kind of stay in the fairway, right? Without without being in too much exposure. So, well, let's turn to state law requirements in Delaware, and we're going to spend a little bit of time here, but we're going to talk about 3 topics, and Alyssa's going to guide us through some of this, as well as Rob. We're talking about the annual franchise tax briefly, annual report, and deceptive solicitations. And again, when you look at the slides and you see some of the slides, there are a lot of slides on some of these things. We're not going to, spend minutes and minutes on each of the slides, but why don't we turn to annual franchise tax? And one of the things I think we talked about in preparation that you could talk about, Alyssa, is one of the things that's not listed here is that first step, qualifying to do business, and how that looks and how that can impact some of this annual franchise taxes, given number of shares or whatever you do when you set up to do business.
Well, why don't we start with what we have to do in Delaware, and then the qualifying to do business would be separate. But essentially, depends upon what kind of entity you're forming. If you're forming a corporation, you're issuing, authorizing an entity to issue shares of stock, you pay an annual fee that's called a franchise tax fee. That's because the entity is essentially a creature of the statute. The government is giving you permission to establish this. And that franchise tax fee that's imposed each year is based upon the number of authorized shares that a company puts in their certificate of incorporation when they form the company. So, for example, if you're a public company, you may need tens of millions of shares authorized. But if you're a closely held company, you don't want to authorize more than 5,000 shares and allocate them proportionally to get the ownership right, rather than authorize millions and millions of shares, or you're going to get a very big franchise tax bill. There's one exception to that. There's another method of calculation that the Secretary of State will allow you to use. And that is if your gross assets, even if you have a lot of shares authorized, if your gross assets are very small, that will help you take the franchise tax down to the lower echelons. But no need to mess with that. Try to recall not to authorize more than 5,000. And then the annual report that gets filed, unlike in other countries especially, the information is nominal. It's the address of the company, the names of the directors, the names of the officers, and it's very simple to comply with that. It is not meant to give a whole lot of private information, and it's not meant to make that private information public. With respect to an alternative entity, rather than paying a franchise tax, you pay what's called an annual fee. And that is fixed in an amount, a few $100s, and it doesn't change by virtue of how large the alternative entity is in terms of its capitalization or number of members. It's a few $100s a year. No matter what type of entity, and again, there's an annual report that gets filed, notice filing only, very little contained in there. And you have to have a registered agent, no matter what type of entity you are. And what that registered agent is merely the state says, if you're going to organize yourself here and be subject to our law, we need to know, we, the state, need to know how to contact you. And we're not going to run around different addresses and all this to go find you and send notices to you. We want you to commit and give us the name of a professional registered agent. That's somebody who full-time is available to receive notices or information from the state that the state is trying to get to your entity. So in addition to that annual report, in addition to either that franchise tax or annual fee, you will need to retain a registered agent, and they'll be in the range of another few $100s a year for that role.
Did I hear you right? It can't be a natural person?
It could be an
Okay.
individual person.
Okay.
But I wouldn't recommend that because they, you know, if it's an individual person and they're not home, for example, Secretary of State's not going to like that. Okay,
No.
they want a reliable place where there's somebody that answers the door, answers the doorbell, is there to receive mail. So if you're going to use an individual, I'd be careful about that. I'd sooner pay the few $100s and be done with it.
Yeah, I was asking because in Illinois, very similar annual report filings, and our LLC used to be very expensive compared to a corporation, and then a few years ago it changed. But a lot of lawyers like myself sign on as a registered agent at our law office address, so that was why I was asking. What I love about Delaware and the registering for business, like you said, is for information purposes. It's very brief. The articles are very short. Like you said, they have the name of the company, registered agent, and that's about it. There's not a whole lot of other information that's posted right on the Delaware website, unlike some states where they ask for, like Florida, which is surprising, has all these sunshine rules where you have to put ownership and everything of each individual. It gets very complicated.
Let me give you two qualifications to that. The annual reports that get filed, you are supposed to put your officers and directors in the corporate structure, okay? And in addition, with respect to the ultimate owner, what Delaware's had in place, it does not get publicly disclosed, but every registered agent is supposed to know an owner of each entity for whom it serves, an individual who has real ownership in the entity. You must maintain their contact information. But again, that's not public. But if the Secretary of State wants to know, or if law enforcement wants to know, they're going to go to the registered agent and you're supposed to have that information.
Thank you for that. And then again, there's exempt entities. Exempt entities are what, 501c3s, right? So, and they have not authorized to issue capital. There's some other ones as well, right? So they have a different qualification, but they still file an annual report, right? The exempt entities in Delaware.
Exempt entities, I've never filed an annual report for an exempt entity.
Okay.
No.
Yeah. So okay. And there's an annual report that Alyssa talked about, and again, their LPs, LLCs, and general practitioner partnerships are all exempt from filing, and so again, you can take a look at that at your leisure. We want to talk a little bit about the acceptance solicitations, and do one of you want to talk a little bit about this and what people involved in the corporate governance and compliance ought to be thinking about in this arena?
Yeah, I'll jump in. I think the only thing to kind of note here that Delaware has issued advisories saying be aware of people kind of posing as Delaware kind of official Delaware actors that might say you're late for your annual report or some other fee that you're out of compliance with, and then seek that you click some link or you pay some sort of amount to a third party that will administer it. Often, this is just kind of a common phishing scam. It's not limited to Delaware. It happens in 1,000 other contexts. And so, just I think the takeaway here is it can be easy to say I'm gonna defer my compliance to waiting until I get that notice from Delaware, but it probably makes more sense to kind of calendar that you're going to have an annual report due on sometime this date, and check the credibility of all of the communications you get from any third party. Don't click on a link. Go to the website. You can contact people in Delaware to confirm whether something's due, and just take a more active hand in this, and rather than just filling out forms or clicking on things, because there are grifters out there, as there are in every context, and you have to take a little bit more of a hands-on approach to your compliance for maintaining your organization. I would say that if you do use a registered agent, a reputable one, they will help you with compliance as well. So that's one other side of this. If you do get a communication from one of the name brand registered agents, that will help you quite a bit rather than relying on other automated alerts.
I'd agree with that, Rob, and I'd say that, the registered agents, it's the Secretary of State sends those annual notices of fees owed, et cetera, to the registered agent. And the registered agent by statute is obligated to forward it on to you. So unless you're getting a communication from your registered agent, I would argue that it's probably not legitimate.
Yeah, I think that's right.
Good advice. So let's turn quickly to annual meetings of shareholders. And again, annual meetings can be required by state law where you're incorporated. Every state has its own incorporation laws and corporate acts in a place. Stock exchange listing standards, if listed, your corporate charter or bylaws may in fact require you to have an annual meeting, and what that looks like. And again, one of the things you're looking at is directors, and again, it's a chance for directors of the entity to kind of look over corporate governance, which is the topic we're talking about today in detail. Does anybody want to talk about state law requirements on these? And again, I don't think we need to spend much time on this, but what do you want to just kind of talk about state law requirements that might be out there?
Yeah, I think the basic is, at least, and I don't know, Rob, if you could weigh in, but at least in Delaware, you're supposed to have a meeting each year. If you don't have a meeting, if the meeting is not called, a shareholder can go into court and request that the court order a meeting to be held. But I also note that the real reason to have the annual meeting is for shareholders. It gives them an opportunity to vote on the directors of the company, which manage the company. And I will note that shareholders can also do that by written consent in lieu of a meeting if all the directors are up for election. So there's a little option, but as a shareholder, you would want to make sure you have that right. And I think as part of good corporate governance, you want to offer the opportunity for the shareholders to participate in that way.
Yeah, I would weigh in as well and say that in many cases, many newly formed or startup or pre-capital raise, oftentimes the shareholders and the board are one and the same, or a lot of the same overlap. So you're not going to probably get, if you don't hold the meeting, you probably won't get a shareholders meeting. But the other reason to have the other reason to have these meetings in place and to have them take place is when you do in fact get into a transaction. Rob talked about the CTA and some of the reasons why you might not want to comply there. Same thing here is one of the things that due diligence, if you're the buyer, you're going to ask for these minutes because you want to know who owns the company. You want to know who's the directors, you want to know what other actions may have been taken. And so one of the things that often happens is that if you don't hold the meetings, and you get to that stage, I've had clients that come to me in Illinois and other places, and we'll do a catch up and a ratification type of annual meeting because they haven't kept good records for whatever reason, right? They haven't had the meetings. They're just opening up their business. They're running their business. They're not thinking about the niceties of and formalities of what's required to be in good corporate governance stead, which could be a bad thing, but in any event. As Alyssa said, if you don't hold the meeting, you can have judicial intervention, or a shareholder can go. And 44 jurisdictions in the Model Act provide for court-ordered meetings. Again, you don't want to. My advice to most of my clients is you don't want to, for the most part, you don't want to end up in front of judges and in court fighting over this stuff, especially on things like this, because it's going to cost money. It's going to cost time. You're probably going to get chewed out from the judge and have to go through the hassle. So does Rob, do you want to talk about the stock exchange requirements, or Alyssa, and how these could?
Sure.
Again,
That's federal. That's federal. So that's Rob's and Dan's bailiwick.
Sure. No, I mean, a lot of the annual meeting, I think Dan kind of described it well. I think when you're kind of a small, closely held business, the importance of that meeting will depend on kind of how diverse your shareholder base is and how active they are, and the difference if they're kind of passive and need an annual check-in, or if there's really kind of one and the same with management. I think when you have that kind of closely held arrangement, it's kind of like filing your taxes. It kind of forces some good housekeeping that comes with it. But if you don't see a huge litigation risk because everyone is on the same page, it is relatively simple to kind of come up to date with some of these items and address them at a later point. It's not the end of the world. If you're a public company, it's a different story. You could get this delisted. You've got a broad base of different shareholders. The board needs to represent them, and in accordance with your bylaws, you need to have elections of your directors at minimum. Also, often on that agenda slate would be in order to at least get a quorum to have a valid vote. Often they have approval of the auditor because that can be automatically voted for by the stock exchange, the brokerages that own shares directly. And then often there are executive comp decisions as well. There's a big focus on whether leadership are paying themselves too much, whether directors might be kind of beholden to leadership and kind of giving them sweetheart deals. And in the annual meeting, they have an opportunity to say whether shareholders have an opportunity to kind of vote and say whether they approve that or not. They also have an opportunity to vote and approve major kind of benefit plans, particularly equity plans, as they expire and need to be renewed. I think there's a lot more that can go into this. This is where kind of shareholder activism comes in, and the leverage point for shareholders to get involved in kind of inserting their own directors or having a new agenda for the business, maybe changing the entire leadership team. But that's for another agenda, another seminar at this point. I just say that it does get much more complicated as you become a public company. But we'll stop there at that point.
All excellent advice. Oh, go ahead. Go ahead.
I was just going to say that, when you raised shareholder activism, Rob, I also thought of how in the alternative entities, like all the funds, the limited partnerships form the funds, there's a ton, they under our Delaware alternative entity statutes for LLCs and limited partnerships, there's no annual meeting required.
Yeah.
If you're not public, there are listed partnerships and stuff, but if you are not listed, there's no requirement. But it is the error of shareholder primacy. So whether you're owning an interest in a fund or a corporation, I'd highly suggest, as Rob described, the benefits of having some sort of get together with your investors so that they feel like they know what's going on.
That's excellent advice. The other thing with the stock exchange, and we're not going to go into details, but the stock exchange requirements also have requirements for certain state regular committees, an audit committee under both NASDAQ and New York Stock Exchange, as well as independent directors and a lot of other stuff. But again, that's a different seminar than this one. So, and again, most if you've ever attended a public company's annual meeting, unless it's Berkshire Hathaway, where Warren Buffett and Charlie Munger used to sit for 8 hours on stage talking and telling stories, and you can go buy a bull of a watch or whatever he's got, See's Candy. You got the gecko walking around. I mean, most of them are, when I was in house, they're surprisingly, they're all scripted, right? For the most part, there's a lot of what's known as proxy. So maybe 10 shareholders that really think because they own shares and 100 shares in a company, they're owners, they show up, and it's just not a very exciting event, because it's voting on directors, and then it's voting on the auditors, and maybe there's something else, depending. If there's a shareholder activist, that could be exciting for sure, because a lot of those get into some nasty fights and discussions. And so anyway, we can talk about this, but I think we've already kind of talked about minutes a little bit. I think maybe one of you can talk about, we were talking in preparation about kind of how to go about minutes and what they need to contain and what they don't need to contain, and kind of what that balance looks like.
Yeah, I'll give this a shot. There's a lot of angles to this. At the end of the day, as with any kind of organizational body, minutes are often taken just to record what happened, and sometimes it's just a matter of getting the right level of detail, because it's not reported out appropriately, it's not clear. You'll often find that directors say, yeah, we voted for the comp, or we'll voted for whatever it is, and you'll be like, well, what about these following details, because they're left out. So it's important to kind of memorialize that, because memories are short, whether that be amongst the directors or amongst officers or what have others. It also is important to the extent you're being audited or subject to rules for internal controls, if your board is the control on something like compensation matters, or accounting practices or what have you, to have it recorded that the board acted in accordance with that control. And then the last thing that minutes might achieve for you, beyond just kind of having that record, is to kind of record that they abided in accordance with their duties. And maybe, Alyssa, you can kind of touch on those fiduciary duties. But the board ultimately is an agent of the shareholders. They have fiduciary duties as shareholders, and they can't just rubber stamp things. And so the minutes are trying to capture that, while also not kind of giving a transcript for people that might be second guessing those decisions. And
Yeah,
I'll let you take it away.
I think that's a good description, Rob, because when you talk about fiduciary duties, essentially, if you take other people's money and control it, you have to act in a certain way. You got to behave yourself. And whenever you see all these news stories, it's always investors who have given up their money to someone to manage, and they're questioning whether those individuals did right by them. There's a duty of care. There's a duty of loyalty. The duty of care gets at a lot of what Rob was talking about, that you got to show you're actually doing the right thing, that you have proper oversight on the business, you understand the business, you're addressing issues as they come up, the rules that you've established for your committees and such are being followed. Okay, you're holding meetings when you're supposed to, etc. And then there's a duty of loyalty, whereby, the fact that you have control over the operations of the company, you can't go and take other people's money and make decisions where it benefits you or just people you're friendly with, or some people at the expense of others. You've got to act in fairness to the whole company and to all of its shareholders. So those are the duties. And if you think about how you want to establish that you've complied with your duties, that's where the minutes tie in. And I always say it's an art rather than a science as to how much detail you put in those minutes to be able to see that the board, the company's really being managed properly and with respect to its investors. And that's why I would take some time preparing those minutes and thinking about what do I really need that shows I'm doing the right thing versus unnecessary detail that if somebody's asked about it 10 years from now, they're not going to remember that detail. And then it raises its own questions. I will tell you, and I'm sure the two of you weigh in, is that there's always a tug. I strictly advise on transactions or advise litigators on the law with respect to Delaware entities when they're managing disputes, but the litigators don't want you to keep drafts and notes and such. And the transaction lawyers, boy, I want to keep everything so I can show you how I gave you that comment, you rejected it, and it's always a tug too in terms of the underlying documentation that you retain to try to establish that you fulfilled those duties, even beyond the minutes.
I refer to it as the Goldilocks method, and it's a fine balance. Like you said, you need to take time. We also talked in preparation for this that you need to understand the preferences of each committee chair. Again, if you're a public company, there's mandated committees, and there's different styles. There are boards that want name attribution. Dan Cotter moved, and Alyssa seconded it. There are others that just want, a member of the board moved it. Again, for a lot of reasons, right? So there are just different strategies, and like Alyssa said, there's a real tension depending on what aspect of law you're dealing with or advising on at that given time. Because, like I said, the litigators, it's that whole don't write any email or anything, right? That can be taken out of context or whatever. But the transactional people, it sometimes comes down to very particular, right? What did the board actually approve in terms of the comp or the earnout or whatever? And if it just says they approved an earnout, okay, how do you litigate that, right? Yeah,
right.
yeah, and yeah, so there may be Scrivener's error. So good. Corporate charter and bylaws, again, some companies have them. Here's a fun fact. I'm from Chicago. Chicago is the largest municipality in the world that doesn't have a written charter. When it formed in the 1800s, it never formed a written charter. It may explain why many of our mayors are famous for corruption, why many city council members have ended up in jail, as well as a bigger commentary on Chicago in general. I learned that recently, and it blows my mind that we don't have any corporate charter in writing. We're like England.
So how can they be held accountable, or
Yeah.
how can they get in trouble if
Yeah.
it's not their fault? There were no rules.
Exactly.
Good common sense, huh?
Exactly. We've talked already about written consents, and I actually I tell a lot of my clients, especially if you're small again, or if you're the shareholders and board members, Rob or Alyssa, you may have different views, but it's just easier than having an actual meeting where they get together in a room, the two of them or three of them or five of them that
Right.
see each other every day, just to write these written consents. The other nice thing about this is that you can just put a calendar reminder that if May 5th or the third Wednesday of May or whatever is your annual meeting day, you just pull up the last year's, change the dates, right? Make sure that everything's the same and then you don't have to worry about actually right in these minutes. It just takes care of itself.
I would note that if you're using consents for board meetings, though, at least under Delaware law, it has to be unanimous
Yeah,
board action. So every director has to sign that consent. If you can't get every director to sign it, you're going to be stuck with the meeting.
That's absolutely right, and that's pretty common in Illinois and other states that I've done business in. Same thing, and the reason for that is because again, it kind of trades convenience for other things, but there's no discussion and stuff. So the thinking is these have to be issues that are not to be debated, right? That aren't going to be a 5-4 vote or something like that. So, and then I don't know, Alyssa, if you want to talk about electronic meetings and what Delaware says about those. Nah.
Nah,
you can do them,
there's
right?
rules. You have to essentially put systems in place where you know that it can be determined that the person voting is the shareholder of record. And if you're going to have electronic meetings, people have to be able to hear each other.
Yeah. Which sometimes was a problem in early Zoom days, right? It's like seances. Can you see me? Can you hear me? And so I read that one time. It's just like seances. We're going to skip the limited liability companies again. They have the different requirements. And again, meeting best practices. We already kind of talked about this. Robert's rules are not required, but you need some form of semblance of order. The chairman or president or whoever's in charge needs to make sure they have control of the meeting. Again, I don't think we need to talk about all this. We already kind of covered some of these, and given that we're getting down to some a little late in the program, I don't want to bog down in meeting minutes when we've got some other topics to cover and some other things we want to talk about. So the one thing I want to talk about the meeting minutes, and before we get into Sarbanes-Oxley, is Alyssa, you mentioned you're on the corporate counsel commission, I think it is, or task force or whatever.
Corporate counsel.
There's some major changes in Delaware with a few things about section 220 and some other things. Why don't you take a minute now before we talk about Sarbanes-Oxley quickly to kind of tell our viewers about some of these changes and what impact it might have.
Okay. In transactions, there's been a lot you've read about, for example, Elon Musk's, the court said because all the directors were beholden to him, of course, they would approve a $58 billion payment of salary to him, versus the other argument is how many people can do what Elon Musk did, and he warranted a $58 billion pay. But that kind of uncertainty rattled some in the market. So what we have now is, unless it's a going private transaction at issue, that means where management is going to take out many of the investors and therefore have the company no longer be owned by so many shareholders, or reporting if it's listed. It's saying that, look, if we're not dealing with the going private transaction, as long as either independent directors approve the transaction or a majority of the non-interested shareholders approve it, you're good and you're not going to get in trouble. That assumes, of course, that you've given all the necessary information to the shareholders. And with respect to the special committee of directors option, you got to make sure they really are able to act independently, hire their own people, get the right analysis. You have to have backup to establish, or to a record to establish how you determined that these directors were truly independent.
That was Fairlines by 3804 to Fort Myers. Is that
with respect to a going private transaction, you will need both those independent directors to approve it and a majority of the non-interested shareholders to approve it, but only in that situation. What is also helpful is there's now some guidance in terms of what constitutes a controlling shareholder. And it's truly now someone who has to really have voting control, which can dictate the direction a company takes or approve what a company tries to do. At the very least, they have to have, there's a cutoff at 1/3 of the ownership, because in many instances, 1/3, especially if there's a lot of owners, is going to carry the day. With respect to the disinterestedness that I mentioned you need to have with respect to the directors on the special committee and the investors that are going to approve a going private transaction, the Delaware is now recognizing that if you are considered independent for purposes of a stock exchange, you're going to be good for purposes of Delaware law. But again, not everybody's a listed company, so you're not going to be able to fall on that, as opposed to really establishing how you have no direct ties or direct benefits to the people that are making decisions. You're also looking now, there was a lot of lawsuits were moving forward based upon spending a lot of time getting information in what was supposed to be a summary proceeding. There was always, what was permitted was what they called the Section 220 action. Basically, that was where if a shareholder needed some basic information in order to know whether or not there were the facts necessary to bring a lawsuit, they could get some basic information from the company, such as the governing documents of the entity, information on actions that the board's taken, actions that the shareholders approved, but it morphed into something much more. And persons were demanding email correspondence, text correspondence, actions taken for many, many years. The statute now says, look, you're going to get shareholder consents and board minutes, and that's about it. And you can only go back for a 3-year period. Now, with particularized facts, the court's always able to order a more expansive 220 case. But the goal is really to make this the summary proceeding, the 220 proceeding, the summary proceeding it's supposed to be, whereby you went into court and said, we want the information we're entitled to. They get it, and then things move forward. Instead, these 220 actions have been like opening a can of worms and holding the court up and tying up the court with much more expansive requests that are more appropriate within litigation as opposed to the summary proceeding.
Excellent. And we're going to jump ahead to compliance, legal department, or standalone function. We're really not going to talk about that, but in the few minutes we have left, I want to turn to, as I mentioned earlier in the webinar, this kind of changing landscape. And Rob, during preparation, you talked about the design of a program and how good it can be, and have an alignment. But why don't you talk about some of the other things we talked about, just in terms of the changing landscape that we're seeing with respect to corporate governance, some of the new administration's changes and things, and how folks dealing in this role can navigate those changes.
Yeah, I think the compliance function is a quarterbacking role. The head of compliance should be leading investigations, ensuring that things are being attended to, almost like a project manager, but they really can't know everything. So they're, maybe going back to the early 2000s, this is around vintage when Sarbanes-Oxley was coming about and people were exploring, best practices of governance. there was a debate of whether the general counsel could also be the chief compliance officer or not, and what was the appropriate kind of organization of a compliance program. And, is there a way that you could check the box? There were two cases that ruled in a healthcare setting, Tenet and WellCare, that because the general counsel was also responsible for being the compliance officer, and the compliance officer theoretically would be responsible for reporting a violation to authorities, he had an irreconcilable conflict, and therefore couldn't serve kind of in that joint role in those two cases. Sarbanes-Oxley has kind of maybe solved that a little bit, because the general counsel has a duty to report if the company, if their CEO, their boss, or the board don't act with a known violation. So there's no real kind of one size fits all for this at this point. Certainly Tenet and WellCare were very large companies. Not every company has a general counsel, let alone room for a general counsel and a separate chief compliance officer. At the end of the day, an effective compliance program has to be designed for the company itself. It needs to be heard and have general real authority. It needs to be active and actually not just kind of a piece of paper, but taking actions, whether that be auditing practices, updating policies, have a seat at the table with the board, and actually kind of have real authority within the organization to understand what compliance is. But beyond that role of a compliance officer, and that could be a general counsel, it could be a separate person that's the chief compliance officer. Really, you need everyone bought in on this idea of compliance. So just to give an example, cybersecurity is a growing focus of compliance for every organization. And not only is it a matter of kind of risk management, because no organization wants to be dealing with loss of trade secrets or potential liability for disgorging personal information to the public. That's a risk management function. But beyond that, it's also a governance issue, because your insurer will require that. The SEC would require it, and it probably and arguably it's almost becoming such a high priority. It's becoming a duty of care to the board as well. As managing the risk of the company, they should be having eyes on cybersecurity as well. But the people that are involved in IT, in cybersecurity, are often kind of more policymakers and don't actually deal with the IT systems themselves. So you need to work with your IT team to understand the systems, the newest kind of risks, and how they're being mitigated. And the same can be applied across the board in different functions. Harassment issues or discrimination issues are often within the purview of HR. That doesn't mean that they're going to be deciding the law. They have to work in tandem with the Office of the General Counsel. But it does mean that they probably do have a seat at the table. And when you're looking at a compliance program, you need to kind of think about that holistically of other people's roles. Just making sure that your financial reporting is right. That's not the general counsel's role or the chief compliance officer's role exclusively. Certainly is the CFO or the controller has a role in this. And so when you're looking at this compliance program, you need to look at it as to making sure that everyone is involved, starting with kind of the leader, but also the board, the CEO, and management that are leading different functions.
Well, I think we're at the top of the hour, so I want to thank Alyssa and Rob. And if you have questions or comments about this webinar, we didn't see any in the ask question function that we have been monitoring. If you didn't get to ask them during this live program, if you're watching this webinar on demand, please do not hesitate to email us at info@financialpoise.com with any questions or comments you may have. Please include the name and date of the webinar in your email. We'll do our best to provide a timely response. That was a great corporate governance introduction. Thank you, Alyssa and Rob, for your incredible insights and expertise that you brought to this. And we could probably talk for another 2 hours, but that's all the time we have for this episode.
It was a pleasure being with both of you for this presentation.
Shared sentiment. Thank you, everyone. Appreciate it.